Good afternoon and welcome to the February 1st, 2017 Legal and Finance meeting. And we will start out with roll call and determination of quorum. And now we will go to the adoption of the agenda. And we have a motion to approve and a second. All in favor? Aye. All opposed? Motion passes. Now on to general public comment, and I don't believe I have any speaker requests on general public comment. I don't, so I will close it, and we will go to public comment on items, consent items 1 through 13. And I don't have any speaker requests there. Anybody in the audience want to speak on anything, item 1 through 13? If not, I will close it. And we will, if I have anybody that wants to pull anything from on item 1 through 13, if not, I'll look for a motion. Motion. I have a motion to approve and a second. All in favor? Aye. All opposed? Items 1 through 13 pass. We will go on to non-consent items. Item 14 through 20, I will open public comment. And we have 3 speaker requests on item 14, and we'll start with Ron Weifenbach.
This is the right, yep. Thank you, Mr. Chair. Ron Weifenbach, and I live on Augusta Drive. I'm here today to talk about the open and fairness doctrine that we're proposing that the council takes a look at, a hard look at it. I appreciate you giving me some time today, and I'm here to ask the 4 of you that took time out of your day to do your duty today to open up your minds today and look at it with a clear, unscathed, unbiased position. Don't look at the messengers, myself or Mr. Freitag or anything about that. Look at what the doctrine stands for, what it is, and why we're bringing it forward. So that's one of the things I really want you to concentrate on today. So I stand in front of you today to bring this doctrine to you to improve the quasi-judicial process that takes place so often in this room here, and by presenting the doctrine, it'll do a lot of good things for you. I really want you guys to take the time to study it, look at it. Not only study the doctrine, but take the time to study the ramifications of continuing to do what we're doing now. Not looking at anything from an unbiased position, looking at things from a biased position. Whether we recognize that or not, what transpires is a disparate treatment to your constituents, the people that you are representing in the city when they come before you with a quasi-judicial item. They look for you for leadership. They look for you for a process that is fair, unconscionably fair. I know today, just from being here for a few minutes, there's people in here that some of you may not like. You may not like me. You may not like the clothes I'm wearing. You may not like anything I stand for. You may not like my communications there, or what I've done with City Hall in the past. There's other people in here that are probably in the same position. But that's not your position to be the judge in that area. Your position is to be the judge on the merits of what is here in front of you. Why does it or does it not fit? What are the facts that surround it? What are the facts that say this doesn't work, and why doesn't it work? That's what this fairness doctrine is about. It's not about restricting any of your conversation with your constituents, not whatsoever, in any way, shape, or form. What it does, it makes your job easier and better, makes you a better person. It makes your constituents feel more comfortable, more confident to come up here and stand up here and talk to you guys, understanding that they know that you've gone the extra mile. You understand the position you're in a quasi-judicial process. They understand the process. They know that they're going to be treated fairly. They understand that they're not going to have information that is somewhere in an abyss, maybe way over here, or in a cloud somewhere that they don't know about, that all of a sudden pops up at the last minute, or you come here with the mindset that you've already made up your mind. And I've sat in your seat, so I completely understand. It's not something that's happening on purpose. It's a disparate treatment, meaning the treatment that happens because of the process. And it's not right. There's opportunities to fix it. We bring it to the forefront. We look at this doctrine, move it forward, massage it, whatever it takes to get it into place so people know that they're being treated fairly. What this will do is it'll put all the citizens on the same playing field. It'll put the council people on the same playing field, as long as they understand their job is to come here with an unbiased position. I sat during a really very contentious and, it was widespread throughout the city. It was a period of time when the council had decided to censure a person. And I sat up there going, what are we doing? You know, we're the judge, jury, and whatever, executioners. And that's really kind of what you are in a quasi-judicial process. So there has to be rules, and there has to be thorough understanding that you have to walk in with an unbiased conscience. I don't care what someone else said to you outside if the other person doesn't have that same information. We got down to the end about 2 o'clock in the morning. We sat there and wasted everybody's time. And all of a sudden, people started pulling out pre-scripted information that they were going to say in regards to how they felt this person should be handled. I'm like, seriously? We sat here till 2 in the morning? You already had your mind made up before you got here. That's disparate treatment. That's not fair treatment. That's not what you are to do. That's not what the state law says. That's not what the federal law says. You are here to have an unbiased mental state. Even if you feel in your mind that you don't like someone in here, you need to acknowledge that with yourself and deal with it. This ordinance will bring that to the forefront. It'll make all of the information available to all pertinent parties. I'm going to close with something I would like you guys to do is take, this comes from a song that Michael Jackson wrote, and it's called I'm Looking at the Man in the Mirror. And he says, basically, if you want to make Rapid City a better place to live, look at the man in the mirror. And that's you guys. And that's what I'm asking you to do today by taking this ordinance, vetting it with your own vetting sources, not the tainted water that you may have received ahead of time on the Monday morning meetings that you have when other people aren't present. Look at it, vet it, thoroughly see if it has a good place to make Rapid City a better place. Thank you.
Thank you. Mr. Bill Freitag.
Bill Freitag, Brook Street, Rapid City. A couple of things on this ordinance that I want to be real clear about. This hearing is my request, mine and Ron Weifenbach's request. This is not Joel Landine's request for this hearing. This is mine. I submitted an ordinance to you. It happens to be almost word for word. There's 891 words. All of them but 6 of them are the same. And those 6 words are what you have to make your motion on. If you want to approve it, if you want to vote it down, or if you want to send it to council without recommendation, it's my version that you're acting on. If Joel wants to have his ordinance voted on, he needs to get on the agenda and do it. As a courtesy, he's on with me so that you've got his and mine side by side to look at. And they are identical except for 6 words. And those 6 words are this, that if there is a conflict of interest, if there's a bias, that you would recuse yourself from the vote. What Joel would like you to do is just simply tell everybody, hey, I had ex parte communications, or I have a bias, or whatever, and I'm informing all of you about it now, but I'm going to go ahead and vote. And I don't think that's fair. And if you go back just to what you did on just a few weeks ago when you passed your resolution on a conflict of interest, in that conflict of interest, you said if it's money, if it's family, et cetera, that you will acknowledge it and you will recuse yourself from the vote. So you're going to have to tell me in the public why my right for a free and unbiased hearing, a fair and unbiased hearing, carries less weight than somebody's financial interest or family interest or whatever else. I think the number one interest is the person's right to come and have a fair hearing. That's what that's due process. It's in the Constitution, and it's backed up by the South Dakota Supreme Court, which I provided you that case law from the South Dakota Supreme Court. I don't know if you read it or not. But in there, over and over and over again, it makes certain points. If there is unfairness, if there's bias, if there's conflict, you disclose it, and then you recuse yourself. And that's all I'm asking. That's the only difference between Joel and me in our side-by-sides, is that if there is actually a bias, just recuse yourself. Don't go out, don't stay to the end and vote on the deal. Goodness sakes, that wouldn't be fair. Now, I've been told that there's, I've been told that you've been informed that I'm trying to limit your ability to talk to your constituents. You know, anybody that knows me knows that isn't true. There's probably nobody in the recent history of Rapid City that has lobbied councilmen as hard as I have, and you all know that. I'm not trying to limit that, and I do not want to ever affect your ability to talk to any of your constituents. It wouldn't be right, and that's not what this ordinance does. But you have to understand there's two different things, two different groups here. There's the city and its agencies, the agents of the city, and then there's the public. Now, with the agents of the city, that's where you are supposed to get your information about what this hearing is all about. You're not supposed to be told by the agency of the city how to vote, but you're supposed to get your information from them what this is all about. Then everybody comes to the hearing, and if we get to the hearing and it's a free-for-all or whatever, good. That's the hearing process. But we don't short-circuit the hearing by taking this stuff prior to. So if take your agenda reviews that you've done for 1,000,000 years in this city, you go into agenda review, you discuss my cases and the other cases of people in Rapid City. We're not aware of it. We don't get to respond to it, and we don't get to participate. However, the Supreme Court said, if you're going to do that, you've got to inform me of the meeting. I get the right to be there to hear it, and I get the right to participate in it. And then all this ex parte communication stuff. You know, when I was on the Historic Preservation Commission, Joel and the other city attorneys came in there and explained to us very clearly, hey, you can't be doing these ex parte communications. And that was the first I'd ever even heard of it. And after I had that experience, I actually agreed with it. And that's coming from the person who was lobbying you, that you can't be doing that. It short circuits the hearing process. So what this ordinance does, it just tries to ensure that the hearing is being conducted fairly and without bias. Now, when it comes to you talking to your constituents, Joel and I wrestled with this. We've been working on this for months. And what we finally agreed upon was that there would be a 5-day time period prior to the hearing, that was kind of sacred ground. Now, before that, everybody can have at it. You know, you and your constituents can have at it. Not you and the staff can have at it. Anything with you and the staff's got to be turned into a memo and put back in there for the applicant to understand and for the public to understand. But anything between you and your constituents, that's up to you. But during this last 5-day time period, all you would have to do, if you want to just take the easiest way out, you just say to your constituent, hey, I'm limited at what I can say in conversation with you 5 days prior to this hearing. So because of that, I would invite you to come to the hearing and let's discuss it there, but I really shouldn't be discussing it with you now. But if that doesn't satisfy them, your hands aren't tied. Then what you can say to them is, okay, well, you got a really good point. So what I need to do now is I need to get a hold of the applicant. I need to let the other decision makers know, because the hearing hasn't even started yet. And we're going to start talking about the hearing. So we have to have all the decision makers there. You have to have the applicant there, and then have at it. You know, everybody can talk about it. Then you publish it. Then you put it back into the record prior to the hearing. Or, yeah, the record prior to the hearing. So nobody's tying your hands that you can't talk to your constituents, and that's been one of the things that's been brought up. Now, here's another thing that in fairness and due process, and you're going to do it to me today, and I hope you don't. But this, I have the right as because it's my hearing, as a participant in this hearing, it's my hearing. I have the right to any comments you make, anything you guys say from up there, I have the right to respond to it. Now, I don't have the right to interrupt you. I don't have the right to do it any other way, but in order, in an orderly fashion, I got the right to respond to what you say. So if you say something that I believe is not accurate or is biased or is unfair, I have the right to comment on that. Not a 3-minute clock telling me to sit down and shut up. It's not my due process. And it's not your right, it's not the city's right to tell you got 5 minutes to talk about it either. If you want to take an hour on it to talk about it, if that's what you need, that's the way the hearing process works. This timer stuff is a crock. And I'm not in here fighting the timer stuff today, but I'm coming back because this timer stuff is going to stop. So I reserve this right, that whatever comments are made from the public or from you, that I get to come back here again to this microphone and address them if I think that I need to address them. And I'll take questions if you got any for me.
Thank you. If there are any questions, it will be when the item comes up. Mr. Deltek.
Thank you, Mr. Chairman, members of the committee. I've got some information I'd like to share with you. What I've got on the overhead projector is Chapter 12.08, which was Ordinance 5793, adopted in early 2012 regarding sidewalk construction, and I want to drop down to Section 12.08060. That's a little bit better. Section 12.08060 clearly states that for new and existing developments, the construction of a permanent sidewalk fronting or abutting all streets, highways, and avenues shall be accomplished by the builder, owner, or developer of all new or existing residential or commercial buildings within the city, except in the following circumstances. And I've highlighted item number 4 because that's what's important today. When the Common Council in its sole discretion approves a variance from sidewalk improvements or requirements. What I have here is the next piece of information I'd like to share with you are the minutes of the City Council meeting of June 18th of the year 2012. Motion was made by Brown, who just happens to be in the audience with us today. Second by Roberts and carried to approve items 4 through 52 as they appear on the consent items with the exception of items 9, 27, and 29. I'd like to point out item number 16, which was the item approved on consent. which is approve a request from the City of Rapid City for an exception to waive the requirement to install sidewalk per City Ordinance 12.08060 for the property located at 2441 North Elkvale Road, which is Lot 1, Lot 2 of I-90 Heartland Business Park, the location of the Elkvale Lift Station project. So in June of 2012, the City Council, at their sole discretion, approved a variance for the requirements to construct sidewalk per city code on the parcel owned by the City of Rapid City for the Elkvale Lift Station. The reason I bring this up is Mr. Freitag, I believe, is going to be showing a video as part of his presentation for item 14, which states that I was untruthful and misled the City Council based upon the memo that he's attached also to this item. I believe these items that I've presented in front of you shows clearly that I was accurate in my comments regarding the city's installing sidewalks on this city project per the code. That's all I've got to say at this point in time.
Thank you. Item number 16, Susan Fidel.
Hi, I'm Susan Fidel. I'm the CEO of Youth and Family Services. And I want to thank you for the opportunity to visit with you this afternoon. Youth and Family Services has a question and request regarding the city's vision funds, and Chairman Roberts said that it would be appropriate for me to visit with you today. I'd like to begin by expressing our deep gratitude for the benefits of the vision funds, the many benefits that have been provided to the community over the years. These funds really do enable us to envision possible solutions for community problems. They embolden us to pursue ways to come together and to meet the needs of the city and raise the quality of life for everyone in our community. Even though YFS didn't receive funding during last year's request cycle, we deeply appreciated the opportunity to apply and to submit our proposal and have our needs considered. There were many important projects brought forth, and the projects funded will certainly help to address the important issues in our community. The question that I have for you today is twofold. Will the council and mayor be offering vision funds in 2017? And if so, would it be possible to make these decisions and allocations sooner rather than later? YFS has an important reason for making this request. We have a strong start to our campus expansion project, having already acquired the needed land and secured about $4 million for our project. The next phase of our overall funding plan includes the acquisition of New Markets tax credits, and you may be familiar with those. But we are hoping to apply for between $2 and $3 million in these tax credits. Vision funds are essential not only for YFS to qualify for a larger amount of New Markets tax credits, they are essential for us to acquire them at all. Last year we made the mistake, and we admit it, of requesting $4 million in vision funds, too large an amount considering the high number of requests that were made. And also because of the fact that you were just making a commitment for 1 year at a time. We've reworked our plan so that we can shell the upper floor of our building and reduce the initial building costs by slightly under $2 million. Therefore, we're able to request vision funds this year if they're opened up for $2 million rather than $4 million and still be able to carry forward with our project. We had to forfeit last year's New Markets tax credit allocation because the parties interested in funding decided that it was really too risky unless we had funding from the city, roughly in the amount of $2 million. This year we have 3 entities who are highly interested in funding us through New Markets tax credits, but it still will require either a commitment from the city or some miraculous contribution of $2 million from someplace else. Anyway, the trick is that the three entities that might be interested in Newmarket's tax credits will need to know sooner rather than later whether or not we might be eligible for the city's vision funds, because they've got to put their plans into place. When the city helped us to build our campus in North Rapid City in 2003, we were serving about 8,500 children and their families in western South Dakota. Today, we're serving more than 14,000, and mostly in the Rapid City community. We've recently received new grants allowing us to enhance our prevention and intervention services for many disadvantaged children and families, but we are completely out of space. And then in addition to that, we just got word that one of our rented properties is now going to be going up for sale, so we're having to find additional space there too. YFS has been a responsible partner with the city for many years. The city has graciously enabled us to build and expand our facilities, and we in turn have secured the vital resources to fund our operating costs. So in short, while we're not asking for any kind of special treatment and we're not making a specific funding request today, we are hoping that the vision funds will be allocated in 2017. And if so, we are hoping that the city would consider moving them up on the agenda so that we will know before too late in the year to be able to qualify for some of these additional funds. That is our situation, and if you have any questions, I'd be glad to address them.
Thank you, Susan, and we will when the item comes up.
Okay, thank you
you.
very much.
And with that, I don't see any more speaker request forms, so we will close the speaker comment section, and we will go to item 14. Items from the public, request from Bill Freytag and Ron Weifenbach to adopt the appearance of fairness doctrine for quasi-judicial proceedings by adding section 2.04.30 to the Rapid City Municipal Code. And Amanda Scott, you have the floor.
Thank you, Mr. Chair. I believe Mr. Freytag said that he would be open for questions when this item came up.
What can I do for you?
Thank you. So as you stated, some of the city council members see this, and I think the bigger question is the definition of quasi-judicial items on the agenda versus non-quasi-judicial items on the agenda, because you were very clear in using the word quasi-judicial. So I'm asking you if you could identify on any given city council agenda, roughly how many quasi-judicial items are on the agenda? Because as you stated, the relationship between a city council member and the constituents, that has to be almost a free-flowing because we represent them. And your concern are specifically to quasi-judicial items on the agenda, right? If I heard you correctly.
No, you don't have it correctly.
Oh,
Quasi-judicial got inserted into it by Joel. When Joel inserted quasi-judicial into it, I never used those terms. I just used the hearing. And Joel says, no, quasi-judicial covers everything, which is your planning and zoning, your historic preservation, your council meetings, you've got appointed groups that make this, like in building inspection, there's a board of appeals and so on. From what Joel told me, and the reason that I agreed to change the wording I had to quasi-judicial was because that was the legal term that included all of those people.
so, and I'm asking because I just want clarification. So what you're saying is that when you're looking at a city council to make a decision, it concerns all items on the agenda?
Not necessarily.
And that's what I'm asking.
If it's a legislative item,
Okay.
which actually this is kind of a gray area, but this is more of a legislative item because it's an ordinance. It's a hearing to adopt a certain ordinance. So let's say you have a hearing to raise the water bills, or you have a resolution or a city policy you want to address. That doesn't fall under this ordinance. The only thing that really falls under this ordinance is a hearing that's initiated by a citizen. Now, those hearings, you would be obligated to treat that citizen fairly. But if you just want to raise the water bill, you can have all the ex parte communications you want. And the Supreme Court case that I provided you spelled that out pretty clearly. And that's why Joel and I included it in there. And unless Joel took it out and I missed it, but that legislative act, is it still in there, Joel? Yeah, the distinction stuff. Okay, so the legislative stuff doesn't fall underneath this ordinance. Does that answer your question?
Well, yes, if you don't mind, I'd like to address a question to our city attorney then, please. So then, Joel, because I know when the discussion goes back and forth, whenever we're looking at items on the agenda, currently today on the agendas, nothing is identified as far as what fits this criteria versus what does not fit this criteria. Because if we're looking at a 5-day window that we can no longer discuss any items because a public hearing is coming up, I would almost think that I just know as a city council member, I may need some guidance to know, don't talk about this, talk about this. Don't talk about this, talk about this. And if we're going to go with a 5-day window, I may need a reminder of when I can talk about things and when I have to no longer can we la la la, I can't hear anything. So I'm looking for some guidance if we're supposed to be considering tightening up what we already follow, because I understand we follow state law currently today. If we're going to look at tightening this up, what are the items that we're specifically talking about?
Well, I think that recognize a practical consideration of this. No, we don't identify what's legislative and what's quasi-judicial on the agendas currently. As a practical matter, in order for you to understand, because you're not all lawyers, what's quasi-judicial and what these rules are going to apply to and what they aren't, we're probably going to have to, at the staff level at some point, try to make that determination and make it clear. Although the difficult part is going to be that when these rules kick in when somebody files an application, you aren't going to know when an application is filed. You obviously know when the agenda comes out, and you can see the agenda and look at it. And if somebody contacts you, you'd be able to look at the agenda and figure it out. However, if they contact you between filing and the publication of the agenda, you may not know. So there's going to have to be some sort of practical consideration for how to address that. The simplest way to explain it is you're entitled to due process when a decision of the governing body or the planning commission or the zoning board is going to really, when you're talking about the city, affect your property rights, okay? Which, when I discussed it with Mr. Freitag, it was difficult to articulate a situation involving an individual that didn't probably implicate their property rights on some level. That's generally when you get a decision like that involving a specific landowner or specific property owner. And there's case law on a lot of the planning decisions, which again is traditionally when you see a specific applicant, that those are quasi-judicial. So things for variances, exceptions, things like that, those would all be quasi-judicial. I will say that on the 5-day, I was never really comfortable with that, and the way that it's written, it's modified a little bit. There's no free-for-all prior to 5 days, okay? Because frankly, even if we wrote a rule that said there was a free-for-all for 5 days, up until 5 days, if you talked to an applicant 10 days before the hearing, went and did a site visit or whatever, did not disclose that, so that is an ex parte communication. If you went out to the applicant, the other side, the other interested parties were not present, that is an ex parte communication. If at the hearing or after the hearing, somebody who was opposed to the project and was an interested party and found out that you had done a site visit and hadn't disclosed that, they could still challenge that and say, that violated my due process rights, or that was not a fair hearing. And they could mount a legal challenge to that, and then the court would look at it, and they could say, look, city, you have this 5-day distinction, that doesn't matter. The dilemma is, when you have a hearing and you have things continually coming in right up until the hearing, it makes it difficult for people to respond to all of that. On the other hand, you have staff and the applicant should be able to get stuff in within a certain period of time, okay, prior to the hearing for you to consider. But a lot of times when you have a project that involves a neighborhood, the neighbors are sending in emails. They're not probably aware of what the rules are. And if we get an email the day before the hearing, what I had to consider when I looked at this was that it's better, in my opinion, to provide that as soon as possible to everyone rather than at a certain point hold off and only provide it at the hearing. Because I don't think we can say to our citizens, well, I'm sorry, you didn't provide your comment, more than 5 days before the hearing, so it's just going to be completely excluded. On the other hand, if we bring a bunch of emails from the neighborhood on the day of the hearing, then the applicant really isn't going to have any opportunity to look them over or have a chance to respond to them. So the way it's written is everything should be in 5 days before. To the extent that stuff is received less than 5 days before, it will be provided and linked as soon as possible. But if something is received with less than 5 days, if say you're an applicant and somebody sends something to the council or the planning commission the day before the hearing, and you come to the hearing the next day and say, look, I just got this yesterday, I have not had a chance to review it, I cannot meaningfully respond to it today, then they should be given a reasonable opportunity to respond to that. By the same token, if the applicant provides something the day before, the people opposed or staff should be given a reasonable opportunity to respond to it as well. And frankly, whether it be staff or the applicant, if something is presented the day before, it should probably be because, there was something that happened or something that they couldn't have known about or responded to, more than 5 days before. But when I think about the 5 day, I'm really more concerned about just the average citizen who's sending in comments or emails about a project in their neighborhood.
Thank you. And so to clarify, to make sure that I'm not misspeaking, because Mr. Freitag already said that I totally misunderstood what he was trying to say. So just for clarification, I was under the impression when I read through our city council little handbook of what we were supposed to do, that we were already under obligation to recuse ourselves if there was any undue bias on any decision or if we had a pre-made decision before we ever came here. Is that not our current policy? Is that not state law?
Yeah, I would agree with that. And I think that's where part of the confusion in the language. So the language that Mr. Freitag inserted said, if you engage in an ex parte communication, you are required to disqualify yourself, whether or not there's any risk of undue bias or prejudice. The very act itself is essentially assumed to create undue risk of bias or prejudice. Whereas if you look at the ordinance that has been drafted, if it talks about ex parte communications, and if you disclose them, you are not automatically disqualified. Now, if you fail to disclose them and somebody else is aware of them and brings it up and it's discovered you engaged in it and you chose not to disclose that or what the contents were, then you would be disqualified. Now, the next provision says, and that would be subsection 5, a decision maker whose communication, statements, or actions regarding an issue or party involved in a quasi-judicial proceeding demonstrates prejudice or an unacceptable risk of bias shall be disqualified from participating in the proceeding. So if you have bias or prejudice, and it's not tied to ex parte communication specifically, it just says if you have bias or prejudice, you are disqualified, okay? Now, bias or prejudice could occur or be shown through ex parte proceedings. The only difference between what I've drafted and Mr. Freitag has drafted is that there doesn't have to be any showing of actual bias or prejudice or a risk of bias or prejudice. In his, all that has to be shown is that you engaged in ex parte communication.
No, that's not right.
So that is where really the difference is. And I've tried to explain that, but see, it gets confusing because it kind of has this overlap where an ex parte communication could be, the difference is, And the reason state law, so when I talk about state law, I'm talking about the state statute that was adopted. It requires disclosure. Because the reason that ex parte communications are problematic is that if you go talk to somebody outside the hearing process and then nobody knows about it, you are relying on information that not everybody has access to, so the other interested parties don't have an opportunity to respond to that. So the idea is, if you disclose it and what the substance is, that at the very least gives the other interested parties notice and an opportunity to address that, which would cure the essentially harm caused by the ex parte communication. So again, going back to Mr. Freitag's reference to the recently adopted conflict of interest policy, you can't cure a conflict. If you have a conflict of interest, you can't cure that. Same as with this ordinance, if you have bias or prejudice, you can't cure that. So you are required to disqualify yourself. However, just because you've had an ex parte communication does not necessarily mean that you have bias or prejudice. Therefore, it does not necessarily require that you disqualify yourself.
Okay, so thank you. So I'm still going back to first of all, thank you for Mr. Weifenbach and Mr. Freitag for working on this. I can tell that you put a lot of effort into this. And so I'm still thinking that my perception of reading our city council handbook is wrong, because they have provided, and you've worked with them and they've worked with the city offices, a potential ordinance for the city council to adopt, but then you've provided one. So my biggest question here today is I thought as a city council member we were already covered under what we were doing with the state statute, and by having two of these presented, I'm now questioning we need to adopt one or the other because we're not covered. That's the question I have is by having two presented to us, it almost as if we're not covered in how we do our daily business, whether it's even just with resolutions and ordinances or whether it's with quasi-judicial. It's making me question whether I should be talking to anybody.
Well, I mean, anytime you talk to somebody about an item outside of public hearing and there's another interested party in it, I mean, you're taking a risk. And I wasn't able to locate, but I've at times given a memo or some written materials to new council members, and that is due process is one of the issues I cover. And I think I wasn't here for the training for the new council members this July, but again, that was covered, as Mr. Freitag said, we go in and to boards, we try to convey that message to them. You're taking a risk. You know, when you look at the Armstrong case, though, I actually am the one that provided that to Mr. Freitag. You know, part of what I wanted him to see is that even at the court level, Supreme Court level, they say this is a tough issue. This is not something that's subject to black and white law. It's kind of on a case-by-case basis, and that's how we're going to decide if there's prejudice. And while elected officials may like a bright line rule that says you either can do this or you can't do this, this area isn't conducive to that. In answer to your question, yes, there's state law that covers quasi-judicial proceedings and due process, and that's what I'm saying is my ordinance is consistent with that, where the state statute does not require disqualification, it requires disclosure, okay? So that's what the state law says, and you are all bound by that. So my ordinance is consistent with that state law. Now, Mr. Freitag says, well, but there's this Supreme Court opinion that he believes says the opposite, and we've gone round and round about it, and without spending a lot of time, I could articulate to you why I disagree with that or why I don't necessarily agree with what he's saying. Now, that being said, if this got presented squarely to the Supreme Court where somebody said due process absolutely requires you be disqualified if you engage in ex parte communications, I cannot sit here and 100% guarantee that they wouldn't agree with that. But it would require them to overrule the existing state law, which is something that generally they tend not to do. They would try to generally harmonize their opinions with the state law if they could find a way to do it.
Thank you. I may have more questions, but I'll release the floor to my peers.
Mr. Chairman, I'd like to be able to respond.
Let me get Mr. Wright into the queue first, since he was in the queue already, and after that, I'll let you respond.
This whole proposal bothers me. The conflict of interest thing that we passed a few weeks ago, no problem, because I do believe that a member of the council or any elected body that could potentially profit from a decision should disclose that, and that's been done for years. What does bother me is the discussion about ex parte and the examples that are given where a member of the council pulls an item off consent calendar and the comments about judicial process. The interesting part is that this committee in particular, or the Public Works Committee, are non-binding, non-judicial. We're just an advisory committee. In my opinion, the only thing that is binding is decisions made by the council. Is that correct, City Attorney?
Yeah, you're just a recommending
Thank
body
you.
to the council.
So, in my opinion, as a member of the council, the way I do business, if someone does it different, then that's another issue. But in all honesty, I try to seek the facts as best I can, and I don't want any stoppage on that or limits on that. I want to be able to ask questions of who I think I need to ask questions of, and I need to use that in my dissertation or my discernment of what I'm going to vote, et cetera, et cetera. Without that, I can't do my job effectively as a member of the council. And it bothers me to be strapped by anything other than the ability to discuss issues as I see fit and appropriately, because it's most important. And to put a window or a limit saying by a certain date you have to have it. All of us that have been on the council, and I can say that myself, I conclude myself in this comment, that there may be multiple items on the agenda, and I may have a discovery or an issue come up in question maybe an hour before the council meeting, or maybe the day of the council meeting. And as a member of the council representing the people, I have the absolute right and obligation to seek the answer to my question as a member of the council. And I don't need to include it as a quasi-public meeting, nor should I have to call someone that may be related to it directly or indirectly and say, I need you here at this meeting, because they may say, I can't make it. The discussion would occur at the council meeting, and that's where the vote is. That's where the binding vote is, and I think our thoughts should be discussed. And the issue of prejudice. I could easily be accused of being prejudiced in issues related to public works. I'm a civil engineer, been one since 1971, licensed even. I worked for them for 23 years. I like trucks and trains and things that get broke and fixed. Do I have a bias? Probably. Do I have a bias for infrastructure versus other things? Probably. But that's my right. That's my obligation. That's who I am. And I try to represent the people in my conduct. And if they don't like it, they can fire me by voting me out. I think that's the proper way. And I do believe we do have a proper, if we're in abidance with the law, state law, and our recent non-conflict thing, we are doing due process. I think the examples given here are not good. I think that members of the council, this committee can make a recommendation to council, even a member on this council, even though it's a unanimous decision to recommend, may change their mind and have every right and obligation to pull that agenda item of the Monday night council. I think this ties our hands way too much. I respectfully finish my talk. Thank you.
And Mr. Freytag, you can ask her.
Okay. Amanda, to answer your question, how can you know whether something's legislative or whether there's an application to it? It's called an attachment that we've had to every agenda item for a million years. If you're going to look at it just an hour before you come to the meeting, you're not going to know it. Those attachments probably should be made a little bit quicker, but you've got an imaginary time frame here that really doesn't exist. Because if I come in for an application for a property rights issue, I have to be here by a certain day, and if I miss that day, then I don't make that hearing. I have to go to the next hearing. So I go in and make my application, and the publication, there should be a publication right at the time of the application, and it doesn't have to be detailed. It just has to say, hey, there was an application made, so that you are aware of it. Okay, and those memos and those attachments are there so the public knows what's going on, and so you know what's going on. And it's all in the open. It's all full disclosure. There's nothing behind the scene. Now, if you don't like the fact that a citizen has due process and ex parte is part of the due process, all I can say, too bad. You know, that's the way the deal's already made. It's already struck. And so I just want that ex parte communication that you're already obligated to be respected. Now,
Mr. Freitag, I'm sorry, I'm just asking a clarifying question. When you're saying it's attached to the agenda, yet generally we don't get the agendas till Friday and we have a meeting Monday. That's not 5 days. That's 3.
That's what Amanda, that's what I'm saying. It would probably be better to get that stuff on there a little bit quicker.
And I agree with you. Thank you. I thought you were berating me for
No.
not reading agenda items, and I'm like, whoa.
No, I want those agenda items to be in a timely manner, and I want them to be accurate. And I don't want them to be filled with anything that's going to prejudice your vote. I want the staff to give you information that's related to the item. I don't want the staff to tell you, hey, don't vote for this. And that's what happens now. You got all this stuff from staff that says don't vote for it. But anyway, my point, I've got several points here, and I'm going to make them each one. You've got the opportunity, and if you need those memos put on there sooner, tell them. That's your job, not mine. Okay. Then you mentioned that you already have a handbook that deals with ex parte communications, right? And I'm telling you that you already have constitutional law and South Dakota state law that guarantees my rights to due process. Already exists. And if you don't like them and they're too hard for you to follow, not my problem. That's going to be your problem, okay? Now, in the state law, if you bothered to read any of the stuff that you know what, and I got to say, you probably didn't have enough time to read it. Number one, because they didn't post it in time. But that state law that Supreme Court case, it says in there real clearly, even the appearance of unfairness or the appearance of bias, that's all it takes. It doesn't even have to be real. Just the appearance of it is enough to throw a wrench into everything that you're trying to do. Now that's already there. It's already in the South Dakota Supreme Court, and you can read it. You don't have to take my word for it. Then you say, so you got a handbook and you got the state of South Dakota, and God, you really don't want to. You don't know whether or not this trying to influence the hearing beforehand is good or bad or whatever, and it might be inconvenient or whatever. I'm going to take you back just a few days to January 3rd, and Elks Crossing States made an application for a hearing for property rights to discuss an easement on their property. Okay? 3 days prior to that hearing, the mayor sent every one of you a letter, says, don't vote for this thing. Sent you an email, said, don't vote for it. What about due process? What about those people's rights? Did they mean anything to you? And by law, every one of you that got that letter was obligated to recuse yourself from that hearing. So you see how screwed up this was? It's so bad that we couldn't even really have a hearing because you couldn't get a quorum because you all got the letter. You really do need some training on this. And it's not like I'm some kind of an expert because, man, I've just been to school since July. I don't have a lifetime of this stuff like Joel does. I've only gone to school since July on it. And there is some real responsibility that goes with a person's right to have a free hearing, a fair and an honest hearing. And I'll yield to Ron here.
Mr. Weifenbach, I'll let you speak.
I appreciate it. I've been sitting here I want to answer Amanda's original question when she talked about quasi-judicial. Okay, I got a definition here for you, and this is out of a Supreme Court case in California, probably the most liberal state in the nation. They interchanged the word administrative hearings, and it occurs, a hearing is held to apply a rule or a standard. That's A. B, to an individual person, project, or circumstance. That's B. C is, it involves the taking of evidence D is it results in the rendering of a written decision issued by a hearing officer or tribunal, including adoption of finals. That's you guys. You guys are basically the tribunal. The written decision is based on the facts and arguments submitting at the hearing. And I want to make an example for you that you can probably relate to. You go to trial, and you're in a trial, and this is what clicked the light for me when we basically were the judge, jury, and executioners of one of our other councilmen a few years ago. Because I kept saying, why am I doing this? What is this about? I was in your seat, Jerry. I understand where you're coming from. I understand where your heart is, but you're wrong legally. Okay? And legally, what happens is what Bill and I are trying to tell you is you're not functioning under the correct law. You do not even know it. Disparate treatment is a treatment that you treat people unknowingly. You ever heard of discrimination? Purposely? There's what they call disparate discrimination. You folks, when you have your council meetings, are disparately treating people. They don't know. They don't know the information that you have in your head that was given to you on a Monday morning meeting. When you're sitting in a Monday morning meeting and you're talking about these people's information, you're not sharing that information with the person that comes in here with the request to change something. They could come in here literally. They could come in here, make their case, and you guys could say nothing and just vote them down, and they walk out and they're completely frustrated. That's not serving the purpose. As a council person, in my discussions with a previous city attorney, and this is what's going to get you guys in trouble, is he would always say to me, and this was during the landfill thing when I told him, what are you doing? I think there was another one where we were trying to sue people in Big Sky, and I kept asking him, what are you doing? What are you doing? This information needs to be available for everybody. And he said, Ron, we can do whatever we want until somebody brings effect to it. You know what that means? That means until someone sues you, Jerry. Because in your heart, you're a good person, and I know you are. I've sat with you. I know that. I understand that. This ordinance protects the city, the taxpayers. It protects you. It protects everybody involved. Is there room to make training for you guys? Absolutely. Trust me, I sat in your seat. The training that you need on this is not here. I sat one time and trained for 8 hours with Linda Lee Viking on Robert's Rules of Orders, and they come back after I had a hiatus and just nothing but chaos. And somebody tells me, we're going to use Robert's Rules of Orders. Well, then use them. People need to come here to get due process, and I'm trying to hope that makes sense to you guys. It's like how in a trial, and all the information is not given to the defense attorney. And he brings his client in, and boom, he's hung out to dry because you guys had the information here. You never shared it in a timely manner with everybody involved in a quasi-judicial process. And there's the differences. You have these Monday morning meetings when you're talking about Ron Weifenbach, and he's applying for an application. You guys are back there talking about me, biasing your mindset, getting a letter from the mayor telling those poor people in Elks Crossing they don't even have a clue they don't have a clue he got that letter from you guys. You guys because he's a leader, you get a biased position now. Mayor wants us to cast this out. Luckily, there was enough of you that could see from your own judgment, and that's what I want you to do today. Use your own judgment, because get the information, vet the information, ask the questions, man. I hope I answered it a little bit. And I understand where you're coming from, Jerry, but it has nothing to do with communication with your people. You got to disclose it. You got to give everybody all the same information. If the staff is telling you something isn't right, why isn't it right? Show me the rule in the ordinance or wherever it is, the policy, procedure, or whatever it is, where it's wrong. Don't come up here and start stating an opinion. Give me all the information. I noticed tonight we're just talking about some warp. You might want to think about that one, Amanda. The warp that the city did. Then they told you they don't. No, you thought you were in the understanding all sidewalks are going to be put in. Well, the city came in and asked for warp. Were you told that? Had you been told that, it would have made a difference in the way you rendered your opinion. I'm just saying, guys, everybody's entitled to a fair trial, and that's what we're asking for. I don't want to keep going on because I know, and there's a lot of questions. And do there need to be policy changes? Absolutely. Do there need to be procedures? Yes, absolutely. Yep, I'm fine. Thank you.
Thank you. And Amanda Scott, you have the floor again.
Thank you, Mr. Chair. I'd like to make the motion to send this to council without recommendation, because I'm sure the other 5 people are going to weigh in as well of what they thought that they were, because I will admit, oh yeah, may I have a second, Jerry, may I retain the floor?
You may have a
Thank you.
second.
Because I know the full 5 years that I've been on city council, I truly try to accept facts based as presented no matter where I get them. And when I come in here, I try not to have my mind made up. If anybody has ever watched the way I conduct myself, I like to listen to all of the hearing or the evidence or the comments. I know a lot of things we deal with are emotional, and I know that you want to just feel for the people, but if you go back to the facts, that's where you have to make your decision on. So I do appreciate the information coming forward today, but I will tell you, I can't speak for every single city council member sitting on this council today or in the past or in the future. But I do know we are briefed that we are to represent the people and to keep the best interest of our citizenry and the city itself when we make our decisions. But thank you.
Thank you. Councilwoman Modrick, you have the floor.
Thank you, Chair. I'd like to call the question.
The question has been called, and nobody is voting on it. Unfortunately, we don't have a motion on the floor. Oh, we do? Oh, I didn't hear you before you started speaking, and Jerry seconded it. So we have a motion and a second. All in favor? All opposed?
Just need 1/2 a second here. And it doesn't got to do with your motion or anything. It just-
I gave you a tremendous amount of
Yeah, but-
latitude,
but
Bill.
There was 2 people that spoke, and I'd like to address the second person also, just for.
The motion's already went through the
I don't-
floor, so.
It doesn't got anything to do with your motion. I would just like to be able to speak here for a second. That, and to say this, I've already taken more time what it takes to say it. Dale Tech and I have a
Bill.
difference of opinion. and-
Yes, but you can discuss it Monday night. You can't discuss it now because the motion is closed. We're on to the next agenda item, I'm sorry. So number 15,
Didn't let me address the.
Human Relations Commission.
Mr. Chair, I'd like to make a motion that we continue this to Monday night unless I'm sorry, I do see a gentleman standing up. Were you going to give the report? Oh, okay, if you're here, that's fine. I had asked if anyone was going to be here, and I was prepared to make the motion to send it to council Monday night so that everybody could hear it, but if the gentleman is here, we'll let him do the report.
Mr. Ainsley, if you want to give that report.
Absolutely, thank you.
Thank you.
Andy Ainsley, I am the chairman for the Human Relations Commission here in Rapid City. Was elected such in October. I've been on the commission for 2.5 years. I'm appointed, asked by the mayor and confirmed by the city council to serve. We are a 7 commissioner board, all selected from the community. We deal with discrimination issues within the city limits to do in employment and in housing. And so the chair gives a semi-annual report, and I'm the person to do that this time around. I believe that you would have received my semi-annual report, hopefully. In the last 6 months, we've had 8 calls. The process is if a person feels they've been discriminated, they call the city attorney's office. The city attorney has several questions to ask the person and the complainant, and once it gets through that checklist, it has to be within the city limits. It can't be against a government. Those types of things are handled elsewhere, but we deal mostly in the private sector. And so we had eight calls. 3 were referred to the state outside our authority. We had 4 that were scheduled for appointments with the city attorney's office. And we had 1 case that actually came before the commissioners back in August, and that was resolved amicably. So in addition to hearing actual cases of discrimination, we're also charged with, by ordinance, to get the word out. And maybe some of you have seen some of our public service announcements on TV. Mid-Continent's been very gracious to give us some time to do that. So it's a very delicate line. We're not really in the business by ordinance of soliciting discrimination complaints. We're really tasked with getting the word out that we exist, and the goal is reconciliation, mediation. We were given subpoena power, and we used it in the August case. That only came in by ordinance in 2014. That gave us a little bit more teeth into what we're trying to accomplish. And so we do community outreach through public service announcements. We have put together a PowerPoint. Many of us commissioners have been around making PowerPoint presentations to nonprofit groups. I recently did one here for the Rapid City Rotary, and we're scheduled to make a presentation to the Board of Directors for the Chamber of Commerce. So we're getting the word out. We're also, it's important for us, to continue to be educated on subjects of discrimination. We have a diverse bunch, gender-wise, race-wise, different backgrounds, but we are a citizen commission tasked with helping other citizens in our area. So, continuing ed. We have right now $1,000 is what we're given a year to buy ads, get the word out, and if we're going to expand and maybe get more of the word out, we might be coming to the electeds in the town looking for more money, but we'll let that wait for another time, not here and now. I'll just reiterate what we're about. By ordinance, we're to prevent, investigate, mediate, and prohibit any and all discriminatory practices based on race, color, sex, creed, religion, ancestry, disability, familial status, or national origin with respect to employment, labor union membership, housing accommodations, property rights, education, public accommodation, or public services. And right below that, to protect all persons from unfounded charges of discrimination practices. And we take that just as importantly. One of the reasons I'm on this commission is because of my business background. I'm previously the chairman of the board for the Rapid City Area Chamber of Commerce. And so I kind of come from the business side of things. And so I also happen to have I've represented an insurance company for 25 years, and I typically say in my line of work that you don't have to be wrong to get sued. And, and getting sued can cost money to defend. And so we take that responsibility too. Unfounded charges of discrimination, our business community can sustain quite a bit of expense just in that as well. So it's a delicate, fine line. I think we have a very productive commission right now. And something that just came in today's mail, and I'll conclude with this, but the Rapid City Area Chamber of Commerce, this is their latest membership directory, and it's very colorful color, or front cover of the magazine, part of the powwow, and I think this is a very good statement in the business community of how we are trying to interact in the Native American community. So it all works together. I'll stand for any questions if there are any. Thank you.
Alderwoman Scott, you have the floor.
Thank you, Mr. Chair. I'd like to make the motion to acknowledge this semi-annual report. Second. And if I can retain the floor,
You
please.
may.
Thank you. Well, thank you. I was wondering if we were going to see somebody today to give the report or if we were going to see them Monday night. So thank you for your report. Thank you for letting us know the efforts that have been done for the last 6 months. The written report that you had summarized a lot of it, it is attached to the agenda, so it is available to the public as you have provided and written. So thank you very much.
Very well, thank you.
Thank you. We have a motion on the floor for item 15. All in favor? Aye. All opposed? Motion passes. Item 16, this was brought forward by me. Discussion on the vision funds. I don't see anybody in the queue. Alderwoman Scott.
Mr. Chair, I was going to let you go ahead and say your comments first as far as why you brought this forward at this time, because I do know the Vision Committee is made up of the entire council, And the funds for 2017 Vision Fund, that was the year plan that we did last year when the city council voted to go ahead and release half of what was anticipated to come in for projects for 2017. So I do know that I have not personally heard of anything of looking at the next, 1 to 3 to 2 to, we have to set a project plan, and I have not heard of anything coming forward at this time addressing any future vision funds at this time. So, but I didn't get the cue because I was waiting to hear what you had to say on it.
Thank you, Alderwoman Scott. Yes, and if you will give me a little latitude, that would be wonderful, and thank you for giving me all the latitude on the last one. When I talk to the YFS board and a few of the people on the board, they have the opportunity, like they said, they have the opportunity to get some new market tax credits this year if we can bring the vision funding, in a little earlier in the fall next year. Whether or not we're going to be talking about, putting out funding for 2018 or not hasn't been a discussion that's came up on the council yet. So I wanted to start it early, because if we start it early, hopefully if they do get some of these funds or have the possibility to get some of these funds, they can use those matching funds through the new market tax credits. And it would really be a shame, in my opinion, for them not to be able to have that matching money through the new market tax credits and be able to use it if they have that opportunity, especially with, some of the things that came through on the last round of funding. So, Mr. Wright, thank you very much, Alderwoman Scott. Mr. Wright, you have the floor.
I'd like to make a motion this go to council without recommendation. If I may hold the floor, if I have a second.
You may.
I just want to add that in the discussion we need to have on Monday night on this item, first of all, we have the Civic Center project, which is not decided, and the sole source of revenue to retire that bond issue is in vision funds. And I think until we have a better definition of that, we need to be very, very careful about what we do with vision funds henceforth. And absolutely, there's no provision for these fundings for 17 to be spent because they've already been done and obligated. So it'll be something in the future. So I think we'll talk about it Monday night. Thank you.
Thank you, Mr. Wright. Alderwoman Scott, you have the floor again.
Thank you. And I do appreciate YFS coming before us today and letting us know of their opportunity. But there is a whole I just want to let you know, and I'm sure you heard it last year, so I'm just going to reiterate it though, that it's a whole process when we open up a project plan. So if you're looking for like a decision within the next 60 days, I think even if we fast track this, we wouldn't be able to make that. So I do know that when we opened up, it took a discussion by the city council and the mayor, recommendation of what funds we were going to open up, and then we had to have a discussion on how long of a project plan we were looking for, and then we had to form a committee. That took time. Then once that committee formed, they had to go through all the applications, and we had like $73 million, and I know you already stated you were aware of that, $73 million worth of projects for one project plan. So to open that all up again, I just want you to be aware that if you're looking at trying to get matching funds for a new market credit type stuff, and if it's time sensitive, even if we started today and approved that we were going to open up funds and look at a 2018, it's going to be a long process. So if you have time sensitive stuff, I would encourage you to either provide that information or be realistic in knowing it ain't going to happen at the city government level for this year because there's a real long process to go forward. So, but I do appreciate the discussion. And I do think it is time for us to consider as a city council if we're going to be looking at a 1 year or a 2 year or what we're kind of looking at and see what funds are available. So I do appreciate the discussion. Alderman Roberts.
Thank you, Alderwoman Scott. And if you just give me one more second, if I can ask Mr. Brown a question, because I think there's a little bit of misinformation on this. They're not asking for money right away. They're asking for money maybe a little earlier in the fall than what we did this year for the funding. But I just wanted to start the discussion now because the earlier we start it, the quicker this process can get done. But it isn't a 30 or a 60 day. So that's going to be my question to you, Mr. Brown. I mean, when would you ideally like to have funds committed, or at least, a commitment for these funds?
I would say probably within 6 months, if we could get the discussion going to where we know there's gonna be an opportunity to get that, rather than starting it today. If it doesn't end up until fall, Alderman Scott, it's the idea of getting it started now, so that we know what's going on.
At least the discussion now,
At
because we
least
know.
a discussion, and
Yes.
get it moving forward. If that's what we gotta do to kickstart it, that's what we wanna do. Get it, because I'm sure there's other people. out
There's
there
other
who've done
great
it.
projects out
Yes,
there, so.
right. But instead of waiting till June to start talking about it, or waiting till after an election, we'd like to see it get started now.
Thank you very much. Thank you. Thank you for your questions. I don't see any more questions in the queue, so we have a motion. All in favor?
Aye.
All opposed? Motion passes. Item number 17 from Community Planning and Development, Heartland Retail Center, approve resolutions 2016-104, resolution approving revision number 2, project plan reallocating project costs for tax increment district number 38, a request by Doyle Estes and Kathy Johnson to consider an application for a property generally described as being located in the southeast quadrant of Elkvale Road and Interstate 90. Alderwoman Modrick, you have the floor.
Thank you, Chairman. I'd like to make a motion that, that we approve this resolution. It's a reallocation on the project, and it's not requesting anything else. So I'd like to make a motion to approve the allocation.
I'll second.
Thank you. Alderwoman Scott?
Mr. Chair, and I will be supporting this at this time. The question, Patsy is here. May I ask Patsy a question?
You may.
Thank you. I was just getting ready to say I'll reserve my questions till Monday night, but Patsy, since you're here, I think a lot of my questions on this have already been answered. I guess some general questions I have is, by reallocating this, is this TID done? Is this coming off the books after this reallocation? Is it being paid for? Is it close it up? Do all the other tax dollars go back to the governmental entities of the city, county, and school after this one, or is this a continuation?
This just reallocates the dollars for Phase 2 so that the rest of the expenses can be paid off. We anticipate the payoff in 2021, depending on, the existing revenues that are generated and any potential future ones. So 2021 is when we expect to dissolve it.
Oh, okay. So this is going to go on for at least probably another 3 or 4 years before this TID closes out. Thank you. That was the only question I hadn't had an answer to.
Thank you. And we have a motion on the floor. All in favor?
Aye.
All opposed? Motion passes. Item 18, Section 28, T2N R8E, approve resolution 2016-105, resolution approving revised number 1 project plan, reallocating project costs for tax increment district number 63, a request by the city of Rapid City to consider an application for the property generally described as being located northeast of the intersection of Interstate 90 and Dias Avenue. And Alderwoman Scott, you have the floor.
Thank you, Mr. Chair. And Patsy's still at the podium. May I pose the same question to her?
You may.
Thank you. On this one, Patsy, does this wrap this one up, or is this one a continuation of a TID or an outstanding TID that's going to take a few more years?
It's going to take a few more years, but this particular TID was established after TID number 44, which is Mall Drive. So all of the revenues generated from Tax Increment District 64 were used at the first 7 years to pay off 744. With this reallocation, just to note, the costs that have been actually incurred are going to be about $1 million less than originally anticipated. So we're going to have quite a few savings once it's paid off.
All right. And the anticipated time of this one being paid off?
It's about 4 or 5 years.
So about that 2021, 22 period again? Thank you. Thank you, Mr. Chair.
Thank you. Alderwoman Modrick, you have the floor. And we have no one else, I don't think, in the queue. We have a motion on the floor. All in favor?
Aye.
All opposed? Motion passes. Item 19 from Parks and Recreation, approve special event permitting process for activities in the city of Rapid City, including those using public parkland and/or open space. This was continued from the January 17th City Council meeting. Jerry Wright, you have the floor.
I may be slightly out of order, but I have to make a motion or suggested change to the ordinance, which affects the entire discussion, I think, in 19 and 20. And that be, and we can handle it under item 20, if it doesn't adversely affect this motion. And that is that under the special event definitions in chapter 12 of 20010, under definitions, that it says special events do not include the following. I want to insert item E, events sponsored or managed by Main Street Square, period. And the reason I say that is Main Street Square is not a special event. It's a long-term lease with the city of Rapid City. And I do believe that all the things that need to be concerned by the city, even if they're extra costs. You raise your hand. Question?
I would like a clarification, because I don't think you should be under the impression that this permit is going to be required for the actual events within the square. But Main Street Square occasionally asks for events outside the square on the streets. So those events, so any event that's outside on a public street or park or whatever is going to require this. And so the police department currently reviews those. So I think, I don't know what Main Street Square has to say, but I think, just be clear, when we're talking about any that Main Street Square would be required to get a permit for, is not anything they do in the square. I believe it's just things that are outside the square or expand beyond the square, the leased boundaries. So we're not requiring them to get a permit for stuff that is occurring within their leased area.
Okay. If I may have the liberty of finishing my thought process, and thank you. The intent is that we have a long-term lease with Main Street Square, do we not? The answer is yes. And that lease would appropriately handle special events, expansion beyond it. I think that would clarify. You're shaking your head. But there's some consideration, concerns out there in talking to the Main Street Square people that they're not sure what's going to happen here and how they're going to get hit. Yes. And I don't understand why we can't exempt them. Thank you.
If I may.
Go ahead, Mr. Bigler. You have the floor.
Thank you. Following the last city council meeting when this item was brought up, we were asked to sit down with the folks from Main Street Square as well as Summer Nights to try and get some of the details clarified for those two groups. One of the issues was about needing a permit for every event that Main Street Square held at their facility. And that is not the case. It is only going to be required to have a permit when those events move into the public right-of-way. A number of events close off 6th Street, and there are events that spill over from the square into 6th Street, or there are events that start at Main Street Square and then go up into the park, such as the pumpkin event in the fall. And so those are the events that would require a permit from either the Main Street Square folks or from the third-party folks that are leasing or using the Main Street Square. So there was never an intention to charge or require permit for every event at Main Street Square.
Yes, you may, Mr. Wright.
In the right-of-way, if they set anything on the sidewalk, that's in the right-of-way, correct?
I would say so, yes.
Right? And how often do we do that without going into the street?
Very rarely.
Pardon?
Very rarely in the sidewalk, we try to keep that space open.
Would you mind taking this stand and identify yourself, please?
Is this one hot too? Okay. Hi, Megan Whitman with Main Street Square. Any questions you may have, we'd be happy to shed some clarification on.
Thank you. Help me find in this document, Jeff, where is it clearly stated to protect Main Street Square from being? Because the property that Main Street Square is on
Yes.
is public property. It's just leased to them, correct? Am I understanding that right?
Yes, that is true.
And that's why there's a little gray area there. Why don't we just clean this up and have the special events that are controlled or operated by Main Street Square handled in their lease? Can't we do that? Because there's some ambiguity and some questions I have that when I read this, I don't feel totally comfortable about it.
Actually, the permit is required to hold special events in Rapid City involving 25 or more persons, animals, or vehicles, or combination thereof, open to the general public and taking place on public space that involves temporary or exclusive use of the public space. So that's in any parks, any roadways, any right-of-ways.
Joel Landine, you have the floor.
Thank you, Mr. Chairman. Maybe we can specify that public space does not include the leased area of Main Street Square, but I would not support trying to, within their lease, give them carte blanche to do anything on any public property. Every event is different if it incorporates the park or the streets, shutting down the streets. I think that should go through an event permit, and that's kind of what's happened. I think everyone agrees, and if we need to tweak the language a little bit just to make clear that because Main Street Square is a public space, that it does not include their leased area. And again, I don't have a problem with them not getting a permit within their leased area, but I would have an issue if we tried to extend their lease to give them carte blanche to do anything on any public property without a permit.
Okay, I would accept that if it's okay with Main Street Square.
Absolutely. I think we've really developed a fantastic working relationship with the city. The permitting process that we've gone through has been just top notch, and this new packet I think is going to streamline a lot of things and has been desperately needed. I think our major concern was the open space section, because we would be considered public open space. I think that leased property disclaimer would be great, and we're more than happy to contribute to the fee anytime that we would close the street or do anything above and beyond the plaza.
So can we, by Monday night, have an amendment to this that would reflect that?
I'm sorry.
Okay, thank you. I end my questions.
Actually, we could bring this back in 2 weeks, and I'm saying that because it's pointed out that the reduced fees that we included in this latest version, that was one of the other issues that came up, was that the sliding scale fees based on the size of the event were something that would maybe discourage events from coming to Rapid City. So we've revised those sliding scale fees to be one fee, a $50 application fee, no matter if it's whatever the event. We've changed that section in this version of the Special Events Handbook that's before you this evening. However, it was pointed out that we already have an approval for special event fees that came before you in December with the fee resolution. So we are going to adjust the fee resolution. So we've got an adjustment or an amendment to that coming to the next Legal and Finance. We could wrap all this up in one meeting if that's
So
okay.
to finish my line of questioning, I'll ask, so if we amend it or delay this for 2 weeks, you have no problem with it, land as a package deal, and we'll get this definition on open space?
Yes.
If a council member wants to make that motion, I'm okay with it. Thank you.
Alderwoman Scott, you have the floor.
Thank you, Mr. Chair. I will make that motion to retain this in committee until the next Legal and Finance Committee meeting so that we can see the fee resolution at the same time that we're seeing item number 19.
Very good.
Thank you. And we have no one else in the queue, so we have a motion on the floor. All in favor? Aye. All opposed? Motion passes. Item number 20, second reading and recommendation of ordinance number 6153, an ordinance to amend provisions concerning permitting for parades and special events by amending Chapter 12.20 of the Rapid City Municipal Code. And Alderwoman Scott, you have the floor.
Thank you, Mr. Chair. I don't want to make a motion to start with because I do have a question that if I can address the city attorney, please.
Yes, you may.
Thank you. Joel, immediately I just wanted to pop up and continue this for 2 weeks too, because we had talked about that we would pass the first reading and hold on to the second reading to make sure that this was all wrapped up. Would we be out of line to just go ahead and continue this for 2 weeks and leave it in committee at the Legal and Finance meeting as well?
Yeah, the two items are related, and we're waiting for the fee, so I would ask that be continued as well.
I would recommend and support, if any of my peers want to make that motion.
And I have no one else in the queue if no one wants to speak. So we have a motion on the floor. All in favor? Aye. All opposed? Motion passes. If I can have a motion. I have a motion to adjourn in a second. All in favor? Aye. All opposed? We're adjourned. Thank you very much.